Everybody's here. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Eunice. You are my battle.
Hello. Good afternoon to you. Lovely Saturday afternoon is with us again. And today being the third in the series of January, we are here to give you the community and the Lord. My name is Owusu Frimpong and I am your regular host for this program. And for the next 2 hours, we'll be live on BWTV, BW Radio, live on BWF Solicitors Facebook, live on BWF Solicitors YouTube, and all the social media platforms. Now, let me ask you, are you a landlord? Do you have a property you've rent out? Now, when you rent out the property, what are the conditions as a landlord? Are you a tenant? And if you live in somebody's property and you would have paid your rent and all the other things, I would want to ask you, when you live in the property, what are the conditions? We shall be asking the question, how do I recover my rent deposit from my previous landlord? You moved into a new property and you paid your deposit. How do you recover it? Does the landlord have to give you everything back, or you would have to pay something to cater for the supposed damage you may have caused to the property? The answer is coming, and I know you will love it. Plus all the other questions you have about legal issues here in the UK. Once again, my name is Owusu Frimpong. BWF Solicitors is proud to be associated with this event. But, ladies and gentlemen, brothers and sisters, friends, and, well, folks alike, welcome to the community and the law next. Hello once again. This is the Community and the Law, the program that brings you everything about what you need to know when it comes to the law here in the UK and outside of it. We are here once again on a Saturday afternoon live on BW Radio, BW TV, live on BWF Solicitors Facebook page, BWF Solicitors YouTube. Now, if you go on to the Facebook page, YouTube page of all these platforms and the names I've mentioned, I would want you to do very quick things, a few quick things for me. First of all, like the page. Second of it, subscribe to the page and click on that sweet little black button at the top of there, that small bell. And so that you have notification whenever we put any content on. Then again, you send in your comments, your questions and your contributions, and engage other participants on the platform. So you send in your comment, you ask a question, you greet somebody, and we'll respond and stay as a family, as we call it in our classroom. Then again, if you have any comment, if you have any question, you can call us on 0739920848, or you send a text to our text number 07950422-780. Once again, welcome to the community and the law. Once again, welcome to the realm where we have support from BWF Solicitors. Now, BWF Solicitors is our trusted partner when it comes to the law here in the UK. BWF Solicitors, they are located on the 4th floor of the Anna House, 214-218, Tottenham High Road, in North London, Tottenham, I mean. We go there, we use the Victoria line, Seven Sisters is the station, use exit number 2. You get out of exit number 2. The building in front of you is the Anna House. Climb up there, 4th floor. From 9 a.m. to 6 p.m., Monday to Friday, you will meet BWF Solicitors. They are there, guaranteed. They will help you go through everything legal here in the UK. Now, I say thank you to BWF, and I'll take their message and I'll be back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well, thank you very much, BWF Solicitors. I'm so grateful to you, staff, members of the BWF Solicitors family and everything. Let me get onto the platform and see how many people I have there so I can welcome. First of all, I have Bua Naomi. Good evening, everyone. Naomi, good evening to you. How are you doing? I know you're doing well. Sandra Fraser, as usual, good afternoon, says. Sandy, how are you? Thank you for the wonderful job you do for us. If you go on the platform, Sandra has put every detail of BWF Solicitors there, train stations, bus numbers, telephone numbers, working hours, and all the rest. Thank you, Sandra. Thank you for doing that. Tilly Duman, Nana Jimang, and all the others, I'm still waiting for you. So if you're coming there, as I mentioned earlier on, just pick up the like button, click on it, share the page, and also invite others to join us because there is so much education we're going to have this afternoon. Now, BWF Solicitors, let me still give you what they do. If you are applying for a visitor's visa, or any other visa and you need a legal organization to help you how to make it well, how to make it correctly, visit BWF Solicitors. We have an office in Accra. You can call the number 050-462-2794. The Accra number again, 050-462-2794. Or you call the UK one, 0208-493-7340. Or the emergency number, 077-127-61884. 077-127-61884. Moving on, a few announcements I want to bring your way, and we get things out of the way. Now, the Ghana High Commission has come out with an announcement, and I have had the public notice I want to read out and explain to you. Then I also want to let you know that we have made plans and arrangement for the whole mission, the consular section, to be with us on the program one of these Saturdays, and we would have the chance of asking any question we want to ask. How is the consular section operating? What are the things expected of us as Ghanaians and people visiting the consular section? What is expected of them as staff and the rest of it? But let's concentrate on this one. The High Commission of the Republic of Ghana wishes to inform the general public that effective 1st of February 2023, all applicants will be required to provide a self-addressed, stamped, special or recorded delivery envelope with a tracking number when they submit the application, whether in person or by post. The envelope should be waterproof, strong and big enough to carry the applicant's passports and supporting documents. They're asking us to know that the mission or the Ghana High Commission will not post your passport or documents back to you if you fail to attach the appropriate or required self-addressed envelope. Please be advised that processing time still remains the same. A big question there. What are the processing times? How many days do I have to wait till I see that they have processed my passport? Those questions will be answered when it is that we have them on the program. But please note that from 1st of February, if you are expecting the Ghana High Commission to send back your passport and other supporting documents to you back, please provide a self-addressed, properly addressed. If you get it wrong, it wouldn't be their fault. Self-addressed, stamped, and made special or recorded delivery with a tracking number. Then you send it to them with the application, whether you go there in person or you post that. So they will have the right address, the right paid for service to bring your documents back to you. I was excited when this notice came to me because one person said to me, I've sent my passport to them and for 6 months they haven't brought the thing back. Is it lost or what? Please, this is going to sort the problem out. So make sure you have your self-addressed, stamped, special or recorded delivery envelope with a tracking number when you submit your application, whether in person or by post. This is an announcement from the Ghana High Commission. And I said, we're making arrangements to get them on the program so that some of these things will be better explained. If you have any question you want to ask them, they will have the pleasure and duty to answer you. So that's from the Ghana High Commission. Now let's see what knowledge we can build with BWF Solicitors. Now, we're talking about employment rights. For the past few weeks, we have been looking at issues like that. What are your rights? What type of arrangements or modifications can you make in your employment contract? If you do remember, last week we dealt with that topic. Now, today we're looking at another aspect of employment rights. Now, a worker within the Employment Rights Act 1996 definition is entitled to up to 4 weeks paid leave for every year worked without limitation, where such leave has been taken but not paid. A worker within the employment rights, the Act is Act 1996. The definition says that a worker is entitled to up to 4 weeks paid leave for every year worked without limitation, where such leave has been taken but not paid. This includes agency workers, workers with irregular hours, workers on 0-hour contracts. Last week, I remember I asked Lawyer about 0-hour contracts, and one thing he said that kept ringing in my mind is that, yes, 0 hours. So I don't have any specific number of hours I'm supposed to work. I can work 100 hours if my time and my availability will allow. Now, from what we are looking at, quoted from Smith and Pimlico Plumbers Limited 2021 case, it says an employer can include bank holidays as part of statutory annual leave. And with that, let me welcome my resource person, my learned friend who has conferred on me that title and post. Thank you very much. Lawyer Charles Asma is here with us on the program. Ladies and gentlemen, this is our resource person for today, Lawyer Charles Asma. Good afternoon.
Good afternoon.
Thank you for coming. It's very cold out there, but you braved it all and you are here.
It's always a pleasure to serve the community.
Yeah. Before you do your traditional greeting, I'm talking about people, and we live and we have to work. The book says that whoever does not work, the hand does not work, must not eat. So we would have to work, earn a wage or salary, earn a living, take care of our families and the rest of it. But when somebody takes you into employment, you have your rights. What we put on there, the Employment Act of 1996, is talking about statutory leave, where people have to have time and go and rest. Would you be kind enough to let us know what it is all about?
Thank you very much. So today's nugget is relevant for two reasons. One, so that we know who we are, and two, whether if we have leave, how does it play out? And the first port of call is straight to the law, the Employment Right Act 1996. If you look at section 230, subsection 3, it will tell you that a worker is somebody who performs work or carries out an activity for another under contract of employment,
Right.
or in any other way, but the person performs the service personally. So the key word is personal service. Personal service. What it means is that somebody cannot do it for you. So if somebody cannot do it for you, then you are not self-employed per se. Because if you are self-employed, then somebody can come and do it for you. All you want is the contract is performed for that client. But if you are performing the job personally, then you fall under the purview of a worker.
Okay.
Our focus today is a worker. So we have looked at the statutory definition, section 230, subsection 3 of Employment Right Act 1996. We know who a worker is. And the key word is personal service.
Okay.
Now, there are people who are workers. One, agency worker. Two, 0-hour contractual workers.
Okay.
And of course, from our nugget, we also have people who work irregular hours.
Right.
Let's say as and when. They can be part-time. They can be fractional. They can be this, they can be that, but they are workers.
Okay.
So today, we want people to understand that even if you are not an employee under section 231, you still qualify as a worker under section 233. And if you are a worker, that means you are working for that employer and you are doing the job personally. So you cannot bring somebody to substitute you.
Okay.
Case law clarifies the position that if the person is doing the job themselves, then they are workers. And therefore, there's contractual agreement between them and the employer. If that's the case, then whether employee or worker, you have statutory right for leave.
Okay.
So the leave, we have looked at the case law and also the Employment Right Act, that you have 28 days leave. And the 28 days leave include bank holidays. So if you want to know how many you should get from your employer, count how many bank holidays there are in the UK. We are looking at UK law, not any other. So if you are listening or watching us from any other jurisdiction, we are focusing on UK jurisdiction, England and Wales law.
Okay.
Now, so if you calculate the number of holidays, if you can check that for us to make a case,
Okay.
and you subtract that from 28 days, then your employer should give you whatever you have.
No, so if per my employment contract, I have 28 days as my leave in any financial year.
Yes.
If there are bank holidays, do I count the bank holidays as part or as an additional number of days?
So the bank holidays include the 28 or are in the 28 days. Let me put it simply like that.
Okay.
So if you want to know whether your holidays are up to the statutory limit or not, you check how many holidays are in the UK every year. Then you subtract that from your 28 days.
Okay.
If you have a figure, then you should know that that's what you should have from your employer. If what you are getting is more than what your employer is giving you, then you should know that the job you offer or the service you offer is giving you more than the statutory limit. For example, teachers get 42 days because 6 weeks in every academic year. So even if you take the bank holiday out, they still have more than 28.
Okay.
It doesn't mean that that is what the law says. It means that the employment contract they have with their schools or colleges offers them more because of the nature of the job they do. So if you are not getting what teachers are getting, all you have to do is check 28 days minus the normal bank holidays. How many do I get? Is that what I'm getting from my employer? If you are getting that, then you are okay.
Okay. So you asked me to check. So the 2nd of January is a bank holiday. The Good Friday is a bank holiday. Easter Monday is a bank holiday. Early May Day, which is the 1st of May, is a bank holiday. The 8th of May is the bank holiday for the coronation of King Charles III. The spring bank holiday is the 29th of May. The summer bank holiday is the 28th of August. And we have Christmas and Boxing Day. So eventually what? 9?
So 9.
9 bank holidays.
So if you take 9...
You take 9 out of any number. 28.
19.
19.
So what it means is that if you are getting 19 from your employer, the employer hasn't shortchanged you.
Okay. But if for instance, there are organizations where you have, say, 26, 27 days, and they would say that bank holidays will be separate. Then it means that your employer is offering you more than the statutory limit. Okay.
So then it's plus instead of minus.
What if I don't take it?
You don't take what?
Your leave.
Right. So obviously you are supposed to take your leave, and depending on the arrangement or the policy in place, if you don't, you forfeit. Okay. Some employers are generous to say you can roll it over, or we need it, but we'll pay for it.
Okay.
So depend on the nature of your work and how, quote unquote, relevant you are, you may be required to forfeit your leave for the benefit of business need.
Yeah, so for purposes of the person being very fresh and on the ball all the time, can the employer insist that an employee takes his or her leave?
There's always a dilemma as to taking a leave and meeting business need. And it's a matter of compromise. So the employer will speak to you and say that for the purposes of this, we have to take the leave at certain times in the year. Because you are not going on leave to punish the employer. You are going on leave to refresh, rejuvenate, and come back. So if by leaving is going to affect the business, and by the time you come back, the business is no longer able to survive or be there for you, then what's the point? So it's a case of relevance and also prudent arrangement. So you speak to the employer. So before you go request your leave, the employer is already aware, and so we call it advance notice. So then the employer will factor in that your absence can easily be covered by other existing colleagues, or somebody has to come on board to cover you for the period. So if you ambush the employer by telling them that I'm going on leave tomorrow, it makes it difficult for them to accept, because it's also business need. So that's one thing. Yes, it's your right, but it's also the employer's right to ensure that business needs continues to be met. So that's one point. The second point is that once the notice goes through and it is approved, then it has to be offered. So you are going on leave. Now, this is where the point is. You have the right to go on leave with pay. So if you go on leave, whether you're an agency worker, you are a regular worker. If I say irregular, we're talking about those on fixed-term contract and...
my popular 0 hour.
We have the 0 hour as a separate category. So we have the 0 hour people, we have the agency people, and we have people who are doing, let's say, fixed term, those people who are doing part-time or all the, yeah. So irregular hours, we call you, come and similar to. But regardless of which category you belong to, you are a worker, including employees, super employees. If I say super employees, the definition employees. You have the right to be given or to go on leave, and the employer must pay for that leave. If you go on leave, what do you expect? Your salary or your wage.
Okay.
If the employer says that you've been absent because you were on leave, and so somebody did the work for you, and we use the money to pay the person, then the employer is breaching the law.
Okay. Can I negotiate and sell off my leave?
That's what I'm saying. It's a matter of discussion with the employer. If the employer feels that things are such that they can require you to roll over your leave, then it can be rolled over, or the leave can be bought out. If the employer wants to buy, bear in mind, two things. If you go, you'll be paid. So it's not a case of I'm going and I'm selling it. If you go, you've gone. Therefore, you'll be paid your statutory leave pay. However, if you don't go, two options. You don't go because the employer has opted to buy it out. So then you don't say, I haven't taken my leave. You have sold it out per arrangement with the employer. Or you roll it over into the next year.
Okay.
So more or less your next leave, year's leave will be plus whatever you have carried over. But the law does not require rollovers or carryovers. Otherwise, everybody will be carrying over. And that is why elsewhere in the world, if you keep carrying over, you are forced to go and leave because you have to go and rest.
I understand you're talking about the UK and Wales jurisdiction. Well, UK includes Wales. But in some other jurisdictions, let me say Ghana, for instance, people accumulate their leave so much so that when it gets to the time that they are to go on retirement, they ask them to take their leave, which sometimes amounts up to close to a year, and take your leave prior to retirement. Does it happen here?
It doesn't happen, I should say, often here.
Okay.
I don't know how many times it has happened in the UK, so I cannot be emphatic that it hasn't happened here. I should say, even if it does happen in the UK, then it might be moderate, and for whatever reason. But granted that it happens or it doesn't happen, the point we are making is that if an employee or a worker who has right to go on leave goes on leave, the person must be paid. Okay. If the person if the person with the permission or consent of the employer rolls over the leave period or sells it out to the employer, then the person is deemed to have used that leave for that period because they've sold it out. But if they didn't use it, then they are required to use it as part of the next year's leave days.
Well, folks, the the Employment Rights Act of 1996 defines the worker as we have described, and it says it's entitled to up to 4 weeks paid leave for every year worked without limitation, and where such leave has been taken but not paid. Now, if we're talking about those who can enjoy this right, it would include agency workers, workers with irregular hours, workers on 0-hour contracts, and there's that bit there that says an employer can include bank holidays as part of statutory annual leave.
So the watchword is can. The employer can. So if the employer can, that is why some employers can say that whether holidays or no holiday, you have your 28.
28.
Whether holidays or no holiday, you have more than 28.
Somebody is asking me a very sarcastical question, and I know who you are, so I won't mind you. Do you have all the bank holidays? Yes, I do. And I really enjoyed them. Somebody yesterday was accusing me of being a workaholic, and I said to the person, hard work never breaks a bone. So whatever it is, we still have to work very hard. But all work and no play makes Jack a dull boy, and all play and no work makes Jack a lazy cop. So please make sure you take your leave, take some rest. Rest when you have to rest. Work hard when you have to work hard. But stay within the rules. Laura, is there anything you want to add before?
The question that the person was asking, you see, whether to take your leave or not also takes us to health and safety regulations.
Okay.
Because the whole essence of leave is to refresh and to perform and to be productive. So it's about mental health, well-being, and all that. And that is why somebody can be forced to go on leave because
you need to rest.
Otherwise, they will breach.
Your productivity can even go down, really.
So, as long as the person is performing, and as long as it is not their lack of leave, it's not injurious to their work, then I don't see anything wrong with whether the person goes on leave or not.
Okay. So take your leave, take your rest, and make sure you stay within the regulations required by the jurisdiction that we find ourselves in. Let's see, a few people have joined us. Let me welcome all of you and say thank you for joining us. Wompini Adam, Myvling, that's a name I haven't heard before. Myvling Joyceling Abuaji, lovely one. Lin Abuaji, I'll call you so. Mine is 7 to 8 weeks. Wow, you have a lot of weeks to enjoy. I enjoy it. Go on holidays, enjoy every bit of it, yeah? Okay, now next we have, Tilly is here. Tilly, thank you very much for coming in. The next one is Boate Menu. Good afternoon, everyone. Yes, good afternoon, both. We have Tilly saying that Ademonunkum is here. Good afternoon to you. Nanaji, my senior minister, Brawa, and a class is going on. Yes, I know. If your class prefect is not here, you should go searching for him. Tilly Duma watching it live from Highgate. Nanajimai is watching us from Highgate, so thank you very much. If you're close to the Ghana High Commission, say hello to them for us. The next one is Dorcas Adum. Hello, Lawyer Charles and Brakweku. Doki, how are you? Now, my very good friend, greetings all on board, and I know today we'll have a bit of your lovely intervention. UK is the best place to work. So many holidays. My Evelyn, it's not so many holidays. We work so hard. Maiti says, hello, Sir Charles.
Hello, Maya.
And my boss, no, Charles is your boss. So
no, that's your boss.
I'll leave it there. Anyway, so keep your comments coming through. If you have a question, you can put it over there. We'll pick it up and get our lawyer to answer that if you have any contribution to make. And also, I would urge you to interact among yourselves in the classroom and on the platform. Now, we're coming to the question I have posed. How do I recover my rent deposit from my previous landlord? Now, if you're a landlord and you rent out your place, what is the expectation you have of the tenant? Now, if there's a tenant that pays you deposit and your rent, what is the expectation of the tenant for the landlord when the person moves out of the tenancy? Well, who is a tenant, who's a landlord? Maybe I'll go into definitional issues. Lawyer Charles.
Okay, thank you very much, Brakuku. Viewers and listeners, once again, we come your way. Pleasure to have you on board. And today we are going to learn something that will be of relevance. Our question today hinges on deposit, tenancy deposit or rent deposit that we pay as tenant to our landlords before we take up occupation of the property. And oftentimes, what happens is that some landlords seem to be crafty, and so they have every reason to deny you your deposit because they need it for themselves for good reason. So, but they have a duty under the law to make sure that that money is protected. So who is a tenant? A tenant is somebody who takes up occupation of somebody's property by way of agreement with a view to pay rent every month to that landlord. A landlord is somebody who owns property or land and agrees to give that property or land out to someone, the tenant, for a short period. And that short period is called short hold tenancy.
Okay.
And at the end of that period, the property reverts back to
So
the person.
the obvious question then is, for a short period, say I rent a property for a year and my tenancy agreement says that it's from X date to Y date. Now when it does end, do I have to rewrite or re-sign the agreement, or it can roll over?
So there are a lot of flexibilities. Prior to the expiration of that period, what we call contractual expiring date, the landlord will put you on notice that the time is approaching. Or if the landlord is acting through an estate agent, the agent will put you on notice that the year is getting close and what your intentions are. If the intentions are such that you wish to renew, then it will be renewed on the date, on the contractual expiry date, so that it starts again the following day.
Okay. And if I'm getting to the end of my contract and I want to renew, how much notice or how long should the notice be? And if I want to vacate the property, how long notice do I have to give the landlord?
Right. So obviously, the tenancy agreement will specify the notice period. The main thing is that you go into the property or you rent the property for limited period of 6 months.
Okay.
Up to 1 year max. So it doesn't go beyond 1 year unless it is a leasehold properties that will go beyond 1 year. But if it's a residential property tenancy agreement, usually max is 1 year. Elsewhere in the world, max is 2 years, 3 years. But in the UK, the average max is 1 year. That's 12 months.
Okay.
And the least is 6 months. So and the reason is also to give the landlord some level of guarantee. Imagine you're a landlord, you give your property 1 month, and the person says, I'm leaving. How do you cover your cost in terms of meeting the mortgage payment? So the law is couched such that you are able to be certain that for 6 months or 12 months, you have somebody occupying the property. Now, if it's a case that you are leaving the property, you put the landlord on notice via the contractual agreement that you have. If you know you are leaving as soon as possible, you inform the landlord. What if the period, let's say 6 months, has not expired or it's not even due at all? You are just first part, 6 months, let's say you are in the second month of the 6 months and something has come up and you have to end the agreement. Obviously, you are not going to pay rent for the 4th and the 5th and the 6th month. But you have to make the landlord aware that from this period, your tenancy, you are leaving the property so that they can start organizing themselves for somebody to take up. That's one bit. Sometimes landlords can be strict to say that, well, you signed for 6 months and therefore you have to take it for 6 months. But it's not regular. It's not regular that people are so pedantic that you can't go, more or less. You have to stay till the period. So I would say there's that flexibility. Now, in terms of as we said, the notice period, inform the landlord. The same way, the landlord ought to inform you, the tenant. But you can see that the protection goes towards the tenant much more than the landlord.
Okay.
Imagine a landlord telling you that I'm evicting you 3 months into the
contract.
The contract. The landlord can, provided there are good reasons.
Right.
And such reasons could be that you are not paying the rent. And if the main reason why you are taking up occupation is to pay the rent and you are not paying the rent, then the landlord can take steps. But it's a very high threshold obstacle or duty on the landlord. So they cannot just say go. They have to take steps to ensure that indeed they have exhausted all the flexibility options before they even go to court for anything.
Okay. Now, we'll be looking at ending a contract with your landlord and some of the conditions in. Now, let me look at the tenancy agreement. We'll obviously tell you how long you're staying in there for, how long the contract is for, how much you pay per month, your responsibilities as a tenant, and the rest of it. One particular thing that it's common with all tenancies is the deposit. Why do they have to take deposit? If I don't have it, does it mean that I can't rent a property?
Okay. I should say, much as the law is favorable to the tenant, the law is also mindful that the landlord must be protected in terms of his or her right to his property, and the fact that they are forfeiting that enjoyment for your enjoyment.
Okay.
So the deposit becomes a security for the landlord. And what does that security cover? The security will cover that in case the person or if I say person, I'm talking about the tenant. In case the tenant fails to pay the rent, then there's a fallback security. In case, of course, how long will that cover? You have to be smart as a landlord to ensure that it doesn't go beyond the deposit value.
Okay.
Yeah, but again, you cannot just say they are not paying rent, so you are evicting them. You have to go through process. Again, at the end of the period, remember some time ago we talked about the fact that both landlords and tenants have a duty to the property to ensure that the property is remains habitable. So if you are a tenant and you care less about the property and the property is damaged, then when the contractual period or tenancy period is up, you are leaving, obviously the landlord will not renew it for you because of who you are. However, they will not use their own money to repair, to put the property in back. Your deposit will be used to cover that. So you see that it's a security for repairing damages that the tenant may leave behind.
Is there any statutory amount or number of weeks payment or rent that the landlord will have to take as a deposit?
The standard or the average is that 1 month's deposit. Obviously, some landlords will say 1.5 or twice, but it doesn't go to the extreme of ×3 or ×4, whatever. So the max will be ×2 of the rent value.
So if you say ×2, is it just the deposit? Because I see that people say, or some say that you pay 1 month deposit, 1 month rent upfront before you occupy the property.
So
what does it mean?
All right. If a landlord says that rent is paid up front, what it means that rent is paid in advance. If the landlord says use and pay at the end of the month, then you are in occupation and the rent is paid in arrears.
Okay.
What it means is that by the time the contract is up for renewal, you are owing 1 month because you've already enjoyed free for every so that's the in arrears or in advance. Most landlords opt for in advance because they need the money for their mortgage as well.
Okay.
But some also go for the in arrears. So that's the rent. Rent is different from deposit. Rent is the contractual right the landlord has for giving the property out to the tenant. It is the duty the tenant has towards the landlord by using the property. So you pay the rent. The deposit is the security towards damage to the property.
Does it have to equal a certain period of occupancy?
As I said, what we see happening is that maximum is 2 months rent.
Okay.
Average is 1 month rent. So you pay a deposit equivalent to 1 month rent, or 1.5 months rent, or 2 months rent. So if it's 2 months rent, so you can see that, as I said, the security is more often than not towards the damage to the property. In terms of default in rent payment, I mean, if the person is able to pass the vetting or the assessment and qualifies to be given the tenancy right, then we assume that they are working, they can meet up their rent obligations. So we may not be so worried. Things happen and all of a sudden they can't pay. That's a different matter. But we cannot preempt that there's going to be default. What we can preempt is damage to the property.
So what if I have a deposit of 4 weeks rent, for instance, and for a certain 4-week period, I'm not able to pay my rent and I'm in default? Can the landlord use the deposit to offset the rent that I owe?
No. The landlord will not use the deposit to offset the rent that you owe. And therefore, in terms of using the deposit to cover rent arrears, it's a case of when the tenancy is up and the landlord does not intend to renew, and the tenant owes money.
Okay.
The tenant has not damaged any part of the property.
Right.
So the rule is that they have to be given back the deposit per the scheme. We'll come to the scheme shortly. The landlord will then say that, well, you owe X amount, so I will use it to offset the deposit, but I will not renew the contract. Because the landlord has a choice to renew or not. There's no rule that the landlord must renew the agreement. But the landlords must give a reason why they cannot renew. And it's always a case that they want to develop the property or improve, that's the word, improve the property. And therefore, you cannot live there. Or they are taking occupation themselves, so you cannot live there.
At the start of the tenancy, the tenant is obliged to pay the deposit and the rent. At the end of the tenancy, the landlord is obliged to refund, subject to the property being in shape. If the landlord defaults, what happens?
Thank you. And that's the crux of today's conversation. So since 2007,
Right.
in England and Wales, and the reason why we talk about England and Wales is that Scotland has its own rules and regulations. So we usually say England and Wales. So that's the conversation, our jurisdiction for today's discussion. Now, with England and Wales, the position is that from 2007, landlords must take the deposit and ring fence the deposit. What it means is that they should take the deposit and find a way to protect the deposit.
So you can't touch?
You can't touch,
You
because
can't
it's not your
lose
money.
it.
Your
It's
money
not
is the rent. The deposit is for the... So you become a trustee of the tenant's deposit. And as a trustee...
And it yields some interest.
No, as a trustee, you have a duty to the person, the beneficiary of that trust.
Okay.
So the beneficiary of the deposit is the tenant.
The tenant, yeah.
But the tenant is aware that because of the arrangement, should something happen. So the only way the trustee or the landlord becomes a beneficiary of the deposit is if something happens.
Okay.
So it's conditional to.
Something
if nothing happens,
in damage caused to your property.
so if nothing happens, then can you touch it?
No.
But in the past, prior to 2007, a lot of landlords were touching the property, were using it as if it's their own money.
Right.
And when the tenant is leaving,
It becomes very difficult
to refund because they either have used the money and excuses start. So the position is that government regulated that there should be deposit protection scheme, or rent deposit protection scheme, or tenancy protection scheme. What it means is that that deposit given to the landlord must be secured somewhere.
Right.
And because of that, you do not have to put it in your own bank account because it's not your money. You cannot mix it up with your own money.
Okay.
And you cannot also leave it under your pillow and say, I will keep it safe. It is not your money. So you put it, you give it to an independent person, let's call it a guarantor, to keep the money.
Okay.
If I say guarantor, I'm not referring to the guarantor who will tell
Undersign
the,
anything,
who will
yeah.
understand to say that the tenant will pay the rent. No, I'm talking about an independent body that comes under the scheme that this person should keep the deposit, a third party keeping the deposit for the tenant.
Okay.
Why is that necessary? So that the landlord will now have upper hand
Okay.
to decide how the deposit should be used. So if the landlord does not do that, has the landlord breached the law? Yes.
Yes.
So ask your landlord, where is my deposit? Is it kept in a deposit protection scheme? If the landlord cannot prove it, then you can take them on. Because they are not supposed to keep the money. They're supposed to keep it somewhere with a third party under the scheme. And so at the end of the period, it is the third party that will help with the assessment to say that the money will not come to you. It will go to the landlord to cover the damage or the arrears on the tenancy.
Okay. So if you come to the end of your tenancy and you would want to claim your deposit back, do you have to apply to the scheme, or you just put the landlord on notice to say that I'm leaving at the end of X number of days, so get my deposit ready?
Yes, so the landlord will obviously liaise with the scheme to ensure that, mind you, the scheme is a third party, let's put it that way. So who put the deposit into the scheme? Landlord. So if anybody should go for the deposit from the scheme, it is the landlord. So the landlord must have the money, but the landlord must inform or must make the tenant aware that they have complied with the scheme provision to deposit the money where it ought to be deposited. Let me share something with viewers.
Okay.
So it says that once landlord has received your deposit, they have 30 days. 30 days to tell you. And they will tell you verbally or in writing. 1, the address of the rented property. Of course, that's the tenancy. How much deposit you've paid, and that will be in the tenancy.
Tenancy agreement, yeah.
How the deposit is protected. So they have to specify the scheme they are using to protect the deposit, because there are different schemes, approved schemes. Just like we have approved English language test centers. We have approved deposit protection schemes. So they have to show which of the schemes they have chosen. They have to give the name, the contact details of the scheme, and its dispute resolution service. So they have to tell you the scheme provider and where the scheme resolves disputes regarding the deposit. The landlord must tell you. Landlord must also ensure that the name and contact details of the letting agency is made available to you. If it is through a letting agency, oftentimes you get to know because you deal with the agency on behalf, the agency deals with you on behalf of the landlord. So you know the agency. But if the landlord is doing it through a letting agency, but for whatever reason they are dealing with you, then they must let you know that a letting agency is involved. Then the next thing is that the name and contact details of any third party that's paid the deposit. So if somebody paid the deposit on behalf of the tenant, then that's a third party payer. In that case, the name of that third party who paid the deposit for the tenant must also be known. Now, the information would then go to the scheme that the deposit was paid by the tenant, but through whoever paid on behalf of the tenant. Then we also have how to apply to get back your deposit. The landlord must tell you how to apply to get back your deposit.
Now, I can bet my last cent here that most landlords don't do it.
Most landlords don't do it because most tenants don't really mind.
So do I have to pick up my tenancy agreement, for instance, now, and look through for these things, especially where my deposit is kept,
Yeah.
how it is ring-fenced, how I can apply for it? All these things the landlord must make it known to me in the agreement. If it's not in there,
not necessarily in the agreement. The laws, the provision, the scheme says they must inform you within 30 days of receiving the deposit.
so can I go to my landlord now? People are going to be evicted now because I'm going to ask them to ask. Can they?
But it's a right, and therefore you can ask the landlord. I want to know whether the deposit. I want to know which scheme
You put my
is
deposit.
my
into.
deposit protected.
If they haven't
That's a fair
if they
question.
haven't done it, what do you do?
If they haven't done that, you remind them
That
that
they
you
have to
know
do
that the deposit must be kept with a scheme. The fact that if hasn't doesn't mean that they're going to evict you. Fine. The worst case is that they won't renew it after 6 months or 1 year. But it's your right to ask anyway.
Before we move on, maybe we'll ask, get people to ask questions, and we proceed with further explanation and details. If, on the other hand, I have put more value to the property and I'm leaving, can I ask the landlord to kind of pay me back? For instance, I come into your property and your frontage is not properly developed. I get people to come mow it, resurface, regrass it, make it, redo your fencing and the rest of it, and I'm leaving. Do I ask for that to be paid back?
So it's a case of why you did it.
For my comfort, maybe.
Okay. So if it is your comfort, then it might not be the duty of the landlord per se to compensate or to reimburse for that. Question number 2, whether it was done with the consent of the landlord. If it was done with the consent of the landlord, then there will be arrangement as to how the cost of that development or
Will be
improvement
recouped.
could be covered. So if the landlord consented to that improvement, then you would possibly have asked the landlord whether you could use part of the rent to cover that, so that you don't pay the rent for 2 months if it is up to that value of money spent on improvement or improving that area you have thought about. And it is important that you seek consent of the landlord because, one, the landlord will equally be happy that the property is even being put into a shape that will add value when you have left. But again, the landlord is not obliged to compensate you for that. Worst case scenario, landlord will say thank you. Worst case scenario, in favor of the tenant, landlord will say, okay, that's fine. I will see if we can share the cost or we can share the cost.
Okay.
But if the landlord is happy to cover everything, then fantastic.
Well,
but the simple answer to your question is that the landlord is not under any duty
to do that. Well, if you just joined us, we're having a very lively discussion, very informative, as to how you recover your rent deposit from your previous landlord. Lawyer Charles Asma has mentioned and told us emphatically that it has to be part of your agreement, and your landlord would have to inform you that your deposit that you've paid, whether it's a 4-week rent or up to about 2 months rent, whether it's been put in a scheme. If the landlord hasn't done that, you have every right to remind the landlord to do that because you need your deposit protected. So when you have to vacate the property, you will have your money back. And also the deposit is a guarantee for the landlord to be assured that when any damage is done to the property and you are vacating it, there will be funds to do the repairs. You can send in your text 07950422780, or you can also call as 0208-123-1016, or the mobile number 0739920848. Lawyer Charles Osma is here, and he is ready to answer all the questions you threw at him. Yesterday on the program Legal Hour, there were a few questions that were left. I will be picking that one up later on and giving them to lawyer to look at for us. But remember, we're here courtesy BWF Solicitors, 214-218 Tottenham High Road. For all your legal issues, if you need a trusted partner, please go to BWF Solicitors. Call them 0208-493-7340 or 077-127-61884. Covenant Grace has a question there. Says, Bravo, please ask lawyer for me. I think that's what you say. People who are on no recourse to public fund who receive energy rebate paid automatically into their energy account, are they breaching the condition of their leave? Meanwhile, they didn't apply for it. I am supposing that probably some people are having issues with that. The energy support that government gives, I think it's about £63.80 for every household every month. And if you are on no recourse to public fund and such is giving you, are you in breach of your leave?
Right. I don't know how the government got your account details to pay the money to you. But I suppose that if the government has your account details and paid the money to you and you did not make any application for it, then the government cannot turn around to say that you do not have recourse to public funds, so why did you receive this? So I agree with him that you didn't ask for it, so why should you be punished for getting it? And at the same time, somebody potentially can say that, but if you didn't ask for it and you received it, why didn't you refund it? But the question is, every household. Are you a household? Yes. So if it is for households, then it is not for people with restrictions on their leave, or people who have leave, or people who don't have leave. It is for households, and it is to ensure that households are supported through the crisis, the energy crisis and the cost of living crisis. So I would say that I wouldn't worry about the government made payment to me and I didn't ask for it.
Yeah. Well, there's one question says, I'm in a house and I am struggling to pay my rent and bills. A friend wants me to come and stay with them, with my children, as they have enough space, but the estate agents say they won't allow me to go as my contract will end in August. So even if I left, I should still have to pay till the end of my contract period, but I can afford it. What should I do now, lawyer?
So that's the point. That's the point, you see. Now, if you go, the person is already owing anyway. So it's even in the landlord's interest to say go early so that it doesn't pile up. So what should the person do? The person has a choice to stay to the end but cannot pay. Then let them take her and to court.
Does it come pay?
Then she will make a case that I even wanted to go, but they restricted me, so I stayed. But they know I can't pay anyway. And if you go, if they allow you to go, you cannot pay. That's why you are going anyway. But her question is that they don't want me to go, even though I cannot pay. If they know you cannot pay and they don't want you to go, then stay.
Well, that's quite emphatic. Mavelyn Joycelyn Abuaji says, next topics for employee, it says, for employee of sick payment or doctor signing you off work, but your company needs you back. I think probably she's asking if
I think I get a question.
You are needed back, but you've been signed off by a doctor. What do you do?
Why are you needed back if you are not fit to work? This person is very important, yes. Without this person, the business cannot survive, yes. But this person, even if they come, they cannot do the work.
So why do you want me back?
So why do you force them back? So if you have your doctor's note that you are not fit to be at work, that is enough. You ignore, they cannot do anything.
The person that sent in the message that says that I'm struggling to pay my rent and the rest of it. He says, I am not owing. And even though I am having difficulty to cough out the money
She's
every
still
month.
being responsible.
She's still being responsible.
Right.
I want to leave.
What do I do?
What do I do?
So that's the difference.
Okay.
So she's honorable and she wants to remain honorable. They are not allowing me to go. And if I don't go, I cannot pay. And if I don't pay, I become dishonorable. Well, my sister, at the end of the day, if they don't want you to go, you can choose to go. Of course, they cannot physically restrict you. But what they are saying is that they will calculate how many rent left on the tenancy and bill you.
Okay.
So why then don't you write to them to tell them that so it becomes evidential, because eventually it will go to court. Because what will happen next is that you can't pay until the period is over. Because once the period ends, they will let you go anyway, because they won't renew. But they will see that you now owe, and they will take you to court because they cannot evict you forcefully. So they will take you to court. They have to go through the court process, seek warrant to come and evict.
Okay.
So at that point, you might have accumulated, let's say, 8 months or 5 months or whatever bill on the rent. But you have a reason to say that I told you so.
So if you put them on notice, then obviously you have a case.
Yeah, so write to them, write to the estate agent, send email that, yes, I know my contract is up to this period. Unfortunately, I'm not able to continue
because
with my
I'm
rent
struggling.
obligation because of X, Y, Z. And I don't see my financial circumstance changing positively over the next 12 months. And therefore, I want to end the agreement. They write back to say that we are sorry, we cannot end the agreement because it is fixed for 6 months or 1 year. Then you write back to say, thank you, but unfortunately I cannot keep up the payment, and therefore, please let me know what you want to do next.
Okay. William Boadu, welcome on board. Let me pick this one up where it says, please, I have a friend who came here as a student and she has successfully completed. How can she renew her stay?
So if the person has successfully completed, I want to believe that the person's leave has not yet expired. They can switch to any route, the skilled worker route, or they can go on the graduate scheme provision.
Okay.
Yes.
All right.
But they have to do it before. And there are restrictions on the graduate scheme. Because if you failed, sometimes if you fail exam, it becomes a restriction. If you are bonded or on scholarship, it becomes a restriction unless you are released from that bondage, so to speak. And again, you should have completed the course. And the university has informed the Home Office that the course is now complete. You've received your certificate. So if your visa is expiring tomorrow, you can put in the application today if you have received your certificate. Okay.
This one came on our local thing, and I want to put that one on. Can you sue your local council for not taking black mold and damp in your property seriously after several complaints which has caused your young child to have asthma? Your child's GP and school have written to the council for the family to be moved, but the council has said the damp and mold is not bad enough for the family to be moved as they have painted off the mold, but it always comes back after painting. The councillor of the council has also written to them, but still, the child has been, oh, that's serious. The child has been writing suicidal notes because she feels that like she might one day not wake up from sleep due to the damp and mold in the bedroom, which the school, the GP, and the city councillor are aware of. The child's mental health now is affected. What can the family do? That's a very serious
one. Yeah, this is serious. I mean, this is extreme. I know there are issues of mold here and there, but this is extreme to the point that the child is suicidal. If the evidence are obvious, then our family here should go to the council, should make a request. Should make a request. Obviously, this is, I don't know whether it's a council property or it's I think it's council property.
It must be a council property.
Yeah, so it's a council property. So they have to, normally when you inform the council, they come to the property to inspect. They will ask you to send, but it's like they have done everything.
In this case,
they have done everything.
A GP is aware, the school has written to the council, yeah. A councillor has come in.
Yeah.
So why are they?
Yeah, they have done everything necessary. So what they have to do potentially is to...
Can they seek the services of a lawyer?
Of course, but in terms of the specific question they asked, is the council breaching its duty? The council appears to breach its duty in tort because they have a duty towards the people they put into properties. Much as you want to help, you also have a duty to ensure that the help is beneficial. So if the help is creating issues, then again we are looking at Health and Safety Act. So the Health and Safety Act, you can see that it's being breached in a way because the council's property and it's not habitable enough. Then that again comes under Section 6 of the relevant law where the council, which is the public agent body, the decision it is taking is not in the best interest of another provision of the law, which is the Health and Safety Act. So the decision they have taken not to do anything is again breaching their duty under health and safety provisions.
Okay.
And they cannot do things that will break other laws. So they are all over the place as a council. And I don't know why, even with all the interventions from the counselor, the GP, the school and all that, the council is still pedantic. What can they do? I think as soon as possible, they have to, let's assume that they are not looking for property. The council should be able to relocate them. Because even if because there are children involved.
Because there's a risk to a child.
Exactly.
To the point of writing suicidal notes.
They have to involve a lawyer as soon as possible because they've involved all the people that matter. It's not working. They've tried themselves. It's not working. They have to involve a lawyer. Potentially the council will take it serious from that because we don't want the child to die before they open up investigation.
If they are in a council property, obviously, there must be a social worker involved.
I suppose, but the person did not mention the intervention of social service, but you can see that there are children involved, and therefore social service should be informed as well.
Well, that's pushed me back, really.
It's sad, though.
Please, consult a lawyer, or probably, first of all, seek the social services intervention as well, and see what they can do. Well, I have another one here. I am a first-time applicant to regularize my stay in the UK using direct access to my child living with her mother. Regarding financial requirements, my landlord's circumstance has changed, and he's now on benefits, so I've moved to another person who is offering me free accommodation and financial support. Do I still need supporting letter from my previous landlord stating when his support for me started and ended? Then my new landlord will also write supporting letter from when he started to date, or I only need my current landlord to write a support letter for my fee waiver application and main application.
I mean, we are making a current application, so it is your current circumstance. So
Okay.
we want to know where you live, address. So if the address is through free support of other people, the rule is that a letter from that person to confirm that yes, they are keeping you there. And of course, this person appears to be destitute from the description of his circumstance. That's why they are seeking fee waiver. So they have nothing to do with the previous landlord. It's more to do with the current helper.
Okay. Well, the numbers are active and ready for you to call in 020812311016 or 07399208468. The person that brought in the one that says the agents will not allow her to move. It says, my employers are even helping me to pay. So I owed them every month and they want me to come and stay with them. I even went to the agent with my manager to tell them that I can't pay and I need to leave. But still they say I have to stay till the end of the contract. Well, lawyer says,
I mean, if they say stay, I mean, that's freebie, isn't it?
They've asked me to say.
Stay, but after 1 month, 2 months, 3 months, they will say you are not paying. They will say, yeah, but how will I pay if I've already told you I can't pay? Then they will say, if you don't pay, we'll take you to court. Yeah, I'm ready, let's go.
Okay.
But
it has to be in writing.
Yeah,
you have to
put them on notice. Let them respond so that it's clear that you applied your best endeavors to do what needed to be done to avoid what has now happened.
Okay.
Yeah.
Well, I think I'll quickly go to the few that were left over from yesterday and we'll look at that. Yamiri says, I have the EU pre-settlement. Can I apply for my sister's case through mine? They're both Italians.
Sister's kids through mine. So sisters' kids are nieces or nephews, and they extended family.
Not.
So even a person qualified, they can't, because extended family is over. And I just want to answer the question based on the fact that it is not even possible. So there's no even point discussing what do you have and da-da-da-da-da.
Okay.
Extended family, it's over.
Okay.
Both in country and
out
of country.
Okay. Now let's pick the other one. It says, Kusia Pia says, I'm an Italian lady, moved to the UK 5 years ago. I've met a young man who I intend to marry. My boyfriend is an overstayer. What can I do after our marriage?
So it says, met a young man who I intend to marry. My boyfriend is an overstayer. What can I do after our? So is she fighting for the boyfriend who is the overstayer or the new?
I'm assuming that the boyfriend or the man in here is the person she's met.
Okay, so and they are here. The other one has overstayed.
Overstayed, yeah.
I mean, technically, we know that after 2021 June, you cannot make in-country application unless you have good reason why you haven't applied under the EU settlement scheme.
Okay.
Again, I don't know when they married, but the person should have been a family member latest by 31st of December 2020. If the person became a family member after that, then the person cannot be considered a family member under the provisions of Appendix UU. So it might be that there's something else that our sister or brother would wish to share with us, which may not necessarily be discussed on this platform. If that's the case, then our sister can contact us. We'll review the points she's raised and ask more questions, seek evidence that will take from there and offer bespoke advice.
Okay. We have somebody on the line. Let's see. The number is 0739920848. Hello.
Hello.
Good evening.
Hello. Good evening. I have a question. I just want to find out something from the lawyer.
No problem. We're ready for you.
I was granted 2.5 years through my son in 2017 under the 10-year route.
Okay.
Then after the 2.5 years, I switched to 5 years route.
Okay.
So I had my first 2.5 for 5 years in 2019.
Okay.
So March it expired, and I applied again for the renewal. But when he came this time, I've been putting back on the 10-year route. But when I was applying for it, I did do fee waiver, but I was only given the fair card. I was presuming because I was a healthcare worker, but I paid the other fee. So I don't know why I've been putting back on the 10-year route.
On the 10-year route.
Okay. Is our sister on the line?
Yes, she is.
Yes.
The patriot is saying,
Hello?
how are you? How are you?
Boko.
Okay, you spoke English, so let me respond in English.
Oh, no, it doesn't matter to me. I thought it was an English program.
Yeah, it is an English program, so let's continue. So, you said that you switched to the 5-year route.
Yes, in 2019.
Okay, and you met the requirements.
Oh, yes, I did. So I was
and
giving
you were going to renew.
Yes.
And they said, and at that point, you applied for a fee waiver.
Yes.
To show that you now do not meet the requirement.
Oh.
Are you with me?
Yes. So because when I did, and I submitted my bank statement and my everything, I was not granted.
I understand, but what you have told me is that you applied for a fee waiver when you were going to renew under the 5-year route.
Yes.
So the first, you met the conditions and they gave you.
Yes.
Second, you didn't meet the conditions, so they waived it and gave you a free fee waiver.
No, I paid it was only that time, healthcare workers, we had surcharge. We were
You
allowed
had a
not.
rebate.
The IHS.
Yes, that was the only thing that they asked me not to pay, but I paid for the fee.
You paid for the fee. You met the 18,600 threshold. Everything. You tick the boxes.
Yes, because I presume because of my earning, that's why they told me that I don't qualify for fee waiver.
All right. How much? Okay. So what I'm saying is that you were earning enough. Let's say 18,600 because.
Oh yes, more than that. Yes.
And your pay slips, bank statement was there, everything, and
Yes,
you were put
yes.
back on the 10-year route.
Yeah, I've been putting back on a 10-year rule when the renewal came.
So how many 2.5s have you had so far?
This one that has been given to me is my third one. I started with a 10-year route in 2017. Then
So,
after,
okay.
yes.
Right. I mean, I'm trying to work out whether you've covered 10 years within the period since you became legal. If you have been switching here and there, moving to different routes, and if all had 10 years now, then...
No, this is the third one.
So 7.5. You are in the seven. You are in the 7.5 period.
Yes.
Right. Okay. So what you are saying is that maybe, just maybe, the Home Office made a mistake to put you on the 10-year, even though you applied under the 5-year route. If that was the case, when was that? When did you receive the decision? Do you know?
Just yesterday.
Yesterday, so it's fresh.
Yes.
So if you believe that they've made a mistake, then I will encourage you to write back to them that you have made a mistake. I met the conditions for a 5-year route. You have put me on the 10 as if I didn't meet the check requirement. So please reconsider your decision. They are human beings.
Because
they are human beings, so they make mistakes.
If the fee waiver had been given to me, then yes, I would understand that.
Are you there?
Yes. Yes.
I'm saying that they are human beings like us. They make mistakes. So when they make a mistake, you tell them that you have made a mistake. They will say sorry and fix it. So make sure you know that they have made a mistake. If you're not sure, approach a lawyer. Lawyer will look into it, check the application you submitted, and write to them that this is what has gone wrong. Please fix it. Okay? They will fix it for you.
Thank you.
Thank you too. Have a good evening. 0739920848 or text or send a voice note 07950422780. We have a voice note here, lawyer. Let's check it.
Good afternoon, Uncle Ureko. Any lawyer Asma. Michiamo. Bebre. Yamin Shamo. Any majuma pamo ye. At the boy community no. Na me pacho we na asa moka about landlord. Na be me rent it from private landlord. Na me wo problem ewo roof a eliki eba both chimneys here in the bedroom no. Na my complaint since 2020. 2020. Almost send you be by me yin ye. Oba when yin ye. My report in this case no. E dey na meet me aye. Me pacho be here adwen check akrasa mo betimi aboa me. Bye-bye.
Right, so some of the landlords are
very notorious.
and they because they operate through the agents are always trying to cut costs. Because the more they spend, the more their commission goes down, isn't it? I mean, I think what they have done is what they have done. They have fixed it. But what we are saying is that they haven't done it properly. So the problem is not resolved. This is where, for example, the person will say that, I'm going to fix it. Right, I'm going to fix it properly. But if you agree for us to offset it against the rent, it's something that our sister can pick up with the landlord. I don't know whether she's dealing with the landlord or the
estate agent.
If it's the estate agent, she can go there with evidence. You see, the game is evidence. Because they think they have done it. you claim they haven't done it. So you go with the evidence to show them that, look, it's still not fixed. And they will maybe find somebody else to come and do it, or they will say, okay, you do it and give us the bill. Then we'll sort it out with the landlord.
Okay.
So this is something that you can, a conversation you can have with the agent or with the landlord, depending on who you are dealing with. But it happens like that.
07399208468. Hello?
So, good afternoon.
Good afternoon, sir.
So, I called my friend 2 weeks ago, about 2 weeks ago. Me and more advised me about me quit Juma Malano. My manager was very rude on me.
Oh,
and
okay.
I arrived into A&E.
Yeah.
After I went to A&E, a GP asked me to take 2 weeks, took a week off to take my pressure. That I did. But I have to go back to work. Although the GP signed me off 2 weeks, I'm in Jumano. I have another job now. If I don't go to work now, or I went back to work. I want to ask, say if I want to go back what the GP is there, now I'm quit Juma on me other job now. Will it omit me persuade Asakimiana? Because every time it may be the man is just rude on me. He talks to me, and sometimes I feel like crying. So I don't know the way forward. Stay in that job. I don't know what's going to happen to me.
So this,
I'm just on the line. Advice what to do, please.
Okay. Director Mpacho is saying.
So yeah.
Good. Director Mpacho, what can be before for person me confirming? I'm saying already was set.
We'll set to know if you could put the volume off and speak to us on the phone.
Chill me too.
Okay.
What can I say? We require ejuma fufro. Who ejuma mienu?
Yeah, mo ejuma mienu.
All right. Nti fufro na we yane de employer no or your main employer no ya aware me boa.
I'm a main employer, and because let me hear mama naked. It's in Omuama, this security company, stop contract. And I mean, one of my managers need to say, I work for this security company. So she can know, say, she can ask that manager, say, oh, do you go and work? Do you see this staff there now? And they will know, say, though I don't come to work there now, I'm working somewhere. They can find out.
What I'm saying is, we are Jumama main place. You say main place, you know, A B. So what you say? And na corner place, one A C. So what you say?
Sure.
Whether B and C know themselves or not, it is not the issue. Question is, so when you say, so we ejuma may be a, when you mean 5 BH in Koya Juma Mercy, especially so what's the way Yari, and to mean by B and what may Juma Manoa. No be away Yaron who could see what Koya Juma Manoa. What's Atum Rano, so winning.
Show you. Okay.
So Sanet here, the Watum Rano, or Motia right straight away, or dismissal. And so I mean, you have to advise yourself immediately because be away yari jail. I don't know okay you mobi, and I just win yari send your cano. It's against the law, big time. Why?
That's the part.
Okay. All right. I think there's a comment from Covenant Grace on the platform. Covenant Grace say it could also be the whether 5-year route or 10-year route. She still has 5 years to indefinite leave to remain. Could that be the case?
Well, the person is in the 7.5 years. The question that came, the issue is whether the Home Office made the right decision or not. And we have concluded that maybe they did not make the right decision because the person made the application on the 5-year route.
Okay.
Then we are also looking at whether it is worth fighting or not. It is what you seek to get that will require attempt to fight back.
Okay.
By fighting back, what the person is saying is that if they're able to amend and put her back on the 5-year route, then after 5 years, she goes to the next level, indefinite.
Okay.
But if they don't, she's in the 7th year, 7.5 year. So she will have to go again because she's on the 10-year route. So to save the last 2.5, it is worth fighting.
Okay.
That is the main reason for fighting back. Otherwise, there's no point fighting back. So I always ask them, how long have you covered? And if you do it, will it save you time? If you won't save you time, then don't worry. If you save you time, it's worth going to fight back.
Oh, okay.
Yeah.
Well, I don't know whether we're done with the questions that were left over from yesterday. There must be another one. Let's see, what is that? Esther says, good afternoon. My partner lives in Ghana and I live in London, but I work as part-time because of my 4 children. What would I do to get my partner here in London to join me?
Okay. You are bringing your spouse to join you. The rules are that you have to show that you meet the financial threshold, 18,600. I want to believe that the children are British citizens, so she wouldn't have to worry about maintenance for the children. So only maintenance for the husband, 18,600. But she says that I work part-time. People work part-time, but their income is more. But let's assume that she works part-time, therefore her income is not up to 18,600. I also want to believe that this person has indefinite leave to remain or is a British citizen. So it comes under Appendix FM. But if this person is a EU national who has settled status or pre-settled status, but a EU national with EU passport, then they are going to bring their spouse. The rules don't pay attention to the maintenance per se. It's all about family unity, the family reunion bit. That's the position of the EU law. So if it is a EU thing, then it can even be easier. She doesn't have to worry about part-time or this or that. But if it is not under EU and she's going under Appendix FM because she's got indefinite leave to remain or she has British citizenship, then she has to prove the 18,600. I mean, exceptions may be that she says that, right, I don't have the 18,600. However, whatever I have is enough to meet the maintenance threshold for people who are on benefit in the UK, so with their spouses and children. So we calculate that, and there's a case law calculation, the case of Ahmed. So if we calculate that, and the person can prove that whatever I get, comparable to those who are on benefit, is the same in terms of my disposable income for food and other bills after my rent, then the person can make that argument and make the application. But the default provision is that, or position is that, you must show that you work and you earn 18,600, apart from proving all the other evidence that you are putting forward. The maintenance is 18,600 or the finance is 18,600.
07399208468 or 020812311016. Do we still have something from yesterday? Let's pick that up one as well. Anita Japoma Japong, please, I'm asking for a sister. Wants to know if it's possible for a dependent of student visa to switch to any other visa or SW and how it is. Or social worker, I don't know.
No, skilled worker.
Skilled worker.
Yeah, and
how is it done? Okay.
Yes, the person can switch to any other route provided the visa has not expired.
Okay.
It doesn't matter whether they are the main person or the dependent. They can switch to the other. And so if the person switches to this one and the student complete his or her course, the person will then become a dependent of the first dependent. It works in that way. So they can switch if they have still leave. How is it done? You make application depending on the visa type you want to apply for. You check to make sure that you have met the requirement for that particular visa application. You complete the form, you pay the fee, you upload the document or you send the document, you book an appointment for your biometric to be taken, and you wait for a decision. If you are still not sure, seek advice or support from a lawyer.
All right. Well, another one, we can pick one more, and we will take a quick break and come back for our quiz segment and draw the curtains down. Today, I want to remind you again that we are coming your way courtesy BWF Solicitors, our trusted legal partners when it comes to the law for all your immigration issues, nationality issues, family law, and what's about divorce, marriage, and all the other bits, appealing against decisions from the Home Office. Speak to BWF Solicitors 0208 493 7340, or you can call the emergency number 077 127 61884. Now, the last one here. Hello, good afternoon. I married in 2018 with my EU partner through local marriage in Ghana, but I got my residence card in 2019. That is pre-settled, and this expires in 2024. My question is, can I apply for my settled status this year, or have to wait until 2024?
So the person was granted pre-settled status because at the time of making the application, they had not spent 5 years in the UK.
Right.
If now they have spent 5 years in the UK, then they can switch from pre-settled to settled.
Okay.
I still have to prove that the relationship with their husband subsist, and also they have to prove that the evidence required are all available, and he or she can say, is it husband? I'm married.
Yeah, married.
Okay. So I wanted to be sure whether I'm addressing a male or female. I think it's generic at this stage. So he or she will have to do that. So I didn't ask how long the person has been in the UK. But I want to believe from what I've said that you calculate how long you've been in the UK because it's about residence test, not legal residence, but residence. Mm-hmm. So if you were a resident in the UK prior to 2018, because you were not 5 years old in the UK, you were given 5 years pre-settled. After the 5 years granted you, you now have lived 5 years in the UK. You can switch from pre to settled without waiting for the 5 years to expire.
Right. Well, folks, it's been a very interesting afternoon. Very nice and full of knowledge and experience. How do I recover my rent deposit from my previous landlord? Lawyer Charles Asma has been gracious enough to tell us what to do, how to go about it. And remember, if it's not in your agreement that your deposit would have to be put in the scheme for ring fencing, please ask your landlord to do that. It could be your sister, your mother, your uncle, whoever is giving you that accommodation. And if the deposit is taken, please make sure it's put at the right place. Now we're coming to look at the quiz that we normally come up with and end on that exciting note. But before then, let's take a break and say thank you to our proud sponsors. I'm talking BWF Solicitors. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner with over 30 years of unbroken service to the community is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
We're still with us on BW TV, also live on BW Radio, live on BWF Solicitors Facebook page, BWF Solicitors YouTube page, and all the social media platforms. Now, at the tail end of every program we do every Saturday on the Community and the Law, we test you with some of the things we would have studied or taken you through. Now, there's a question I am going to pose, and I need answers. I'll give you two options for you to choose from, so get ready. Abbas worked for Ahofe Enterprise under a contract that stated that he was an independent contractor of the company in business on your own account. An independent contractor of the company in business on your own account. Abbas brought a claim for payment of the 4 weeks leave carried over each year until he stopped working per the Working Time Directive, as Ahofe claims he was a self-employed contractor. Abbas brings an action at the Employment Tribunal. Now, the question I'm asking is, what is likely to be the outcome of the claim? Abbas was employed as an independent contractor. He's self-employed and not entitled to paid holiday. Abbas is a worker, so his appeal will succeed. I take the question again. Abbas, that's the scenario, worked for Ahofe Company, Ahofe Enterprise, so to speak, under a contract that stated that he was an independent contractor of the company in business on your own account. Abbas brought a claim for payment of the 4 weeks leave carried over each year until he stopped working per the Working Time Directive, as Ahofe claims he was a self-employed contractor. Abbas brings an action at the Employment Tribunal. So when they consider the case, what will be their likely outcome? As Abbas was employed as an independent contractor, he's self-employed and not entitled to paid holiday. Or Abbas is a worker, so his appeal will succeed. Now, I wrote the answers. Let's go. So it's either one or two. The other day, I dared somebody to come in and answer the question and give me an explanation as to why you're choosing one or two. Today, if somebody will be bold enough, yeah, that's fine. I still have got a t-shirt I can give away. I know when that motivation is there, I get somebody to come in to do that. So what will be the answer? Is it one or two? One says, as Abbas was employed as an independent contractor, he's self-employed and not entitled to paid holiday. Or Abbas is a worker and so his appeal will succeed. One or two. You can text to 0795042270, or you can put it on the platform. Rebecca says it's number one. As Abbas was employed as an independent contractor, he's self-employed and not entitled to paid holiday. Kevin Asamoah says, okay, Rebecca Mwako says number two. Rebecca, you've done one and two, so which is which? Which one do I take? Okay, Kevin Asamoah says is number one. Okay, now I have Ademununkum. Ademununkum says is number one. Okay, Ademununkum says is number one, so thank you for that. Let's see what the next one says. Naomi says is number one. Okay. Who else? Okay, now let me go to, okay, now I have Abena Ativo. Abena, what's saying? Abena Ativo says, number one, as Abbas was employed as an independent contractor, he's self-employed and not entitled to paid holiday. Eric Kwabna Asante, number one. Somebody's now calling. Okay. My producer says I shouldn't take the call, so I'm not going there. But I'll go to the guest room and bring my colleague who I was craving to join me. Okay, let's see who is there. Bam. Number 18. Good afternoon.
Good afternoon.
What's happening to your camera? It's telling me that your picture is not too clear.
Really? Yeah, but I don't know the reason why. Let's see.
Well, I take it like that because I'm running out of time.
Yes.
How are you?
Any better? Yeah, God is faithful, my dear.
Where have you been?
It's been one thing to the other.
Well, my learned friend, my humble boss here says that I am entitled to paid leave. So
Okay.
I'm taking my leave from next week.
We shall see. We shall
Anyway,
see. Fine.
you have come to meet the question. So are you going to
What
answer for me?
question was it? I lost track of it.
Okay, it's on there.
But I've got a couple of questions. I don't know if we
Uh,
still have time.
well, I'll grant you two because we have run out of time. So
Okay.
two quick ones, and lawyer will use the next 5 minutes to answer them. So I'll hand you over to lawyer and
Okay,
put in
then
your
let me
question.
just go quickly. One just came in. According to her, she did the indefinite leave to remain, and then they wrote to her to go and do the biometrics. But apparently, when she got there, they did it all right, but they took her passport from her as well, and she got a bit confused. That was that the process, because normally she thought after the photocopy of the document, scanning everything to them, they will give you back your document. But they've withheld the passport, and she's a bit confused. So, is there any advice on that as to was it the
Why they did
normal
it?
thing to do?
Should
Yes,
I answer that then?
Yes, please.
Yes, tell your questioner that it is normal.
normal. Okay.
That was quite straightforward. Okay.
That's straightforward. Normal, normal. Okay. So the second question, oh my days. Ray could say something. I'm bringing the second question.
Well,
Okay.
I'm still
Yes.
taking answers for my question I put up. Whether Abnativo, we've got Eric Kwabna Sante. Eric says it's number one. Okay, now if you're ready, please come back on.
Yes. A couple of questions pop up yesterday, but I don't know if you've already tackled
We've
them.
dealt with all the questions that were left yesterday,
Well
so
left.
that
Okay. In
should
that
be
case,
okay.
the last one. This sponsor who gave someone work to do, but unfortunately, the hours that she gave to this person to work under her company is not enough for her to generate the annual payment. Sorry, the yearly total payment that actually required by the Home Office. So this worker, it's a bit worried that the employer is not giving her more work. However, he can go and then find a part-time job from somewhere, but he doesn't want to. He just says he wants to stick with the main employer, and it's a problem now. So he's thinking if at the end of the year he's not been able to generate that or be able to receive that annual 21,000 or whatever, would there be a problem? I'll say, well, let me bring it to the lawyers.
So then the annual the gross salary for the year is not up to the 20,400 minimum. What the person is being paid is not enough. The person doesn't want to go elsewhere to top up the wage because it's you who've given me the license, so you should give me work to do.
Yes, obviously, it is this person who needs to meet the requirement for future progression. The rule is that if you are on the skilled worker program, you must meet the requirement. One, you find work that is on the short occupation list. You get a point. The job is paid salary on that
On a skill.
scale or at that scale. You get a point. So the person has accumulated the points and been granted leave to enter to do the work. And what the person is saying that I now do not meet the requirements.
I do not meet it because the person who
Yeah,
gave me the license does not
circumstances
meet
have
it.
changed. So if the person who gave the license does not meet it, then you shouldn't have met it in the first place to come. So circumstances have changed, and we hear a lot of these things. People come, they don't get a job, they were promised and all that. So I don't know what discussions the employer has had, but again, this person is not restricted to this employer, they can switch to another employer whilst the leave is still valid.
Okay, so in a situation where my employer is not meeting the requirement, the person that's giving the original contract is not meeting the requirement, I can terminate that and look for another that will meet the requirement for me?
Because it's a case of you not meeting the requirement. I don't want to say the employer. Mm-hmm. It is you
because
are
if
not
you are not
meeting
paid
the
that, you are
But
still not meeting.
Yeah, if you are not paid, that means you are not keeping to the conditions of your leave. Just like somebody who comes in as a student and is not studying. They are not keeping to the condition based on which they entered.
Okay.
It could be somebody's fault. It could be that the school is no longer there. If the school is struck off and it's no longer running, that means you cannot be a student.
Okay.
So we cannot, yes, we can blame the school, but we don't care about the school. It is you, the student, that need to
So
deal
you would
with
have
your
to
matter.
find some remedy.
So if you are on a program and the employer's promises are not as the promises made to you are not as they appear now, you have to advise yourself, because eventually, because your record will show. So eventually, when you are going for renewal, it might even be the case the employer will not renew, and she will still have to, or he will still have to find somebody else to be able to continue. Then, if eventually you are going to continue, then why don't you start continuing now?
So if anybody is cutting corners and you realize it, remedy the situation.
Well, I don't want to say cutting corners, but if there have been changes to the checklist on the side of the employer, and you realize that things are not what ought to be, the law allows you to. Even the Home Office sometimes will write you to say that find another employer before your leave is cancelled or terminated.
Okay.
So our sister here or our brother here has a choice to switch. But if they say that they are not going to switch, then yes, the employer may be punished somehow, but it is you that may not be able to progress.
All right. Okay, Maiti, I think we kind of have run out of time. I know that a few of the people that have sent questions through you might feel a bit disappointed, but unfortunately we'll have another time to do that next week.
Okay.
So, Lawyer, let's quickly look at our quiz and see what answers there is to give. Now, is it one or two? Is Abbas, as was employed as an independent contractor, be seen as self-employed and that he will not be entitled to paid holiday? Or in that situation, is the worker, so his appeal will succeed?
Thank you. So the test is in how the service delivery plays out, not how the contract is couched.
Okay.
So this contract is couched to appear that this person is self-employed, because it says independent contractor, suggesting that the person is self-employed to the benefit of the employer. But in reality, if we go deeper, we realize that, hang on, this person is working as though he is an ordinary worker or employee, because one, they are performing the service themselves. Two, they are following all the rules and procedures in place at the workplace. Three, they are paid wage or salary like anybody else. Four, they cannot choose to replace themselves if they are not able to work. So they say, okay, somebody is coming to do it for me, so today I'm not coming. I've sent Charles, go and do it. They can't do that. If they can't do that, then they have to perform the service themselves. If they are performing the service themselves, it doesn't matter whether they are independent contractors or not. They are delivering personally. And therefore, Section 230, subsection 3 of the Employment Rights Act says that they are workers, where they are performing the service personally. From here, we want to believe that Abbas performs the service personally, because there's nothing to suggest that he can bring a substitute if he cannot do the job. So we refer to the case of Uber, the Uber case. Remember, 2021 went to Supreme
where they
Court.
said they were employees.
Yes, they were. When they said Uber said they are self-employed, and these people said we are employees like any other employee, and the judge had to make a decision. Supreme Court had to make a decision that are they workers or they are self-employed, And the court concluded that they are workers, they are employees because they perform the services personally. And they cannot choose not to do the job if the Uber app gives them a service. They have to do it. If they don't do it, they will punish them or sanction them in a way. So there are procedures they have to follow and all that. So what's the difference between them and anybody else in the mainstream employment system? So it is what actually happens, not how the contract is put. So a lot of people whom we see as self-employed may end up being qualifying as workers or employees because of how it plays out. And so we say that Abbas is a worker, and so his appeal will succeed because he performs the job himself without bringing a substitute.
Okay, well, folks, that's what it is. So sometimes, as Laura said, not necessarily as the contract is couched, but how the whole thing pertains in reality. And Abbas did not bring anybody to do the work on his behalf, and he rather did it himself. So his appeal will succeed because he's deemed as a worker. Well, quickly as we're rounding up, I'll get Lawyer to do his 1 minute summary and acknowledgements, and we draw the curtains down.
Thank you very much, viewers and listeners. Once again, we are grateful. We are grateful to BWF Solicitors management. Uncle Ben, thank you for the continuous opportunity. And today, in a nutshell, we have asked a simple question. Can you recover your deposit from your previous landlord? We use the word previous because at this point, you are no longer a tenant and your money is still locked up. Yes, you can, provided you met the conditions. What are the conditions? 1, you haven't left bills for the landlord to pay. 2, you have not left rent in arrears. 3, you have not damaged the property for the landlord to repair. And 4, you have kept to the contract, the tenancy agreement to the letter. If that is the case, then your deposit should be given back to you. And the deposit must be given back to you within 10 days from the date the contract or the tenancy ended. You have to make a request, and the landlord must get it for you through the third-party deposit scheme holder.
Okay.
So that is the position. What if they don't? If they don't, the scheme will come to your aid to take the matter on as a dispute to resolve with the landlord. So it is the scheme that will make the assessment to see whether you qualify for a refund or you do not. If you qualify, the scheme will make it available to you and not to the landlord. And if you don't, the scheme will not pay it to you, it will be paid to the landlord. So we believe this has given you an inkling into what sort of right you have as a tenant in terms of your deposit payment. We believe that going forward, you do what is right so that when your term is up for your deposit to be paid back to you, you can confidently rely on the law to get back your deposit. It's been a pleasure coming your way.
Right. Thank you very much, Lawyer Charles Asma, for graciously coming to sit through with us this Saturday afternoon. Now, before we go, Namayeti, you are with KT Educational Consult. You do the English language for people. Briefly tell us, are classes going on? How can people enroll?
Yes, classes still going on anytime, every week, a new subject. So, yes, students are welcome to come and enroll with us. We are getting nice and beautiful testimonies from the results of candidates who, through us, wrote their exams and the results that they got. So, yes, if you want to enroll, just send your number or your name to 075-966-20154, and we take it from there. Thank you very much, Ray.
Thank you very much. And on that note, we draw the curtains. Now, I want to say thank you very much to Lawyer Charles Asma for coming in to support us, to provide us with a beautiful insight as to the topic we brought you. And also to BWF Solicitors, Uncle Ben and the whole family, Lawyer Richard, Lawyer Patrick, Lawyer Charles, Eunice, Debbie, Cynthia, the Lord Chancellor, and to my able producer, Professor Ade, for helping to run this program so smoothly, so very well, and to my administrator Sheila, and of course Pano Dudu for the aesthetics and everything. My name is Oreku Frimpon. Thank you so very much. We have another edition coming your way, same time next week on the same platform. Until then, be good.
Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. How can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude?